It is the 99th day since the doctors put down their tools and remained relentless amid stress by the government to withdraw an offer earlier made to them. The applicants, represented by lawyers James Orengo and Philip Murgor, presented and filed a return to work formula draft stating that those were the terms the union officials want for the doctors to resume duties.
Met, and that was mentioned before the court. We had all the hopes and optimism that would come back and with a final resolution. Unfortunately, we are not there yet. But I'm glad to report on the part of our clients, the union. We have filed in court a return to work formula. It is not the collective bargaining agreement which is the most important document concerning the union. But we have found what, from our client's point of view, is a return to work formula that will take the interests of all the parties concerned. And bring a modicum of normalcy in the medical sector.
Lawyer Eunice Lumalas countered the order, citing that they had not seen the draft till this morning and therefore needs to meet with her client, the Council of Governors, to go through it.
Which we have just reserved this morning, which is titled Return to Work Formula. We have to look at it, because I cannot say that I've looked at it. We expected that we sit down and craft this together, because the return to work formula, its philosophy and grounding is that it's a document that is meant to be agreed upon by both parties. Often, it is a document that talks about the amnesty of employees, for example, on the other side, because there are details to do with how they will get back to work.
So you are not involved in that?
Not at all, not at all. But the natural consequence in this matter is, first, we agree that we need a return to work formula. And as a natural consequence of it is that the strike is called off. We are happy to look at this document and even happily sign it by today afternoon because we believe that where we have come from does not compare to what is outstanding. So we will need probably to look at it this afternoon and have it filed if it is agreeable, because we do not know what terms they have put in this agreement. But as long as it's clear that one of the natural consequences of this document is the calling off of the strike, we expect that the strike should be called off today.
The interested parties, however, stated that it is not possible to have the draft signed since some of the clauses in the return to work formula varies from the last agreement.
The interested party, it is our position that the negotiations have failed and would wish to pursue the matters before this court with the application and the appeal.
Is there any application? Was it failed?
Ms. Lumalas wishes to lift the consent order, then we can
She would have to make an application.
Yes. But we can pursue the matters pending before this court.
Yes.
On the issue of the return to work formula, which we have just been given now,
Yes.
Your Ladyship, it's the interested party's position that the terms in the return to work formula have been varied since the last time we were in court. And we didn't have a benefit of consulting with our clients to verify the content of the return to work formula this morning, because it has just been given now and the court has just begun.
The court, however, is concerned and disappointed on the slow pace in which the matter is proceeding, having mentioned it several times. The judge stated that if the parties fail to agree by 14th March, the court will not mention the matter.
The matter is proceeding. As long as this matter remains pending, doctors have not been able to go back to work because a return to work formula has not been agreed upon. The union, having provided a draft return to work formula that the respondents are ready to look at, but the Ministry of Health, which is the interested party, is hanging tough and appears to be no longer interested in negotiating. We note that the substantive issues concerning the dispute, which are the CBA and the return to work formula, are really substantive issues that should be for determination by the Labor Relations Court. That notwithstanding, in light of the urgency of the issues, the public interest element involved in this matter, and the fact that the poor Kenyans are suffering because of lack of proper medical facilities, we are ready to bend backwards and give mediation a chance even in this court. We appeal to all the parties, including the Ministry of Health, to be guided by the best interest of Kenyans and put aside their differences, their egos, and also give the religious leaders a chance to help bring a compromise and the resolution of this matter. We are now, therefore, giving the parties the final chance in this court to have a compromise in this matter recorded. We shall mention the matter tomorrow at 10 a.m. That is tomorrow, 14th March 2017 at 10 a.m. We urge the respective councils as officers of the court to prevail on their clients to have these matters resolved. Should the matter not be resolved by tomorrow, parties should note that this court will not mention the matter anymore, but will refer the matter to the Labor Relations Court that is still seized of the substantive issues. And therefore, this court thereafter will continue with the appeal subject of the committal proceedings that are before this court. That is the order that we have made.